Here at Scott Legal, we know the complex issues presented by immigration law. We are here to help you navigate the oftentimes difficult road in acquiring or maintaining your immigration status. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. This video has answers to some of the most commonly asked questions about the International Entrepreneur Rule. So stick around. The International Entrepreneur Rule was recently restarted in the United States. This visa option gives entrepreneurs the ability to come to the US for up to 5 years if they meet certain conditions. To receive this immigration benefit, the applicant must demonstrate that the entrepreneur and the business would provide a significant public benefit to the United States, and that the business has significant potential for rapid growth and job creation.
Is the International Entrepreneur Rule a visa?
No. This immigration benefit is distinct from a visa, as visas usually permit multiple entries to the US and also give applicants a status that is consistent with the visa. For example, an E2 visa usually allows you to enter the US multiple times over a period of 5 years, and when you enter, you are in E2 status. This program allows you a single entry under parole status. While parole sounds bad, it is a period of authorized stay that allows you to work at the business you specified in your application.
Can the entrepreneur be a passive investor, and does the entrepreneur need experience?
The applicant must be well positioned to advance the entity's business, and cannot be a passive investor. The entrepreneur must meet one of the following criteria to satisfy the rules. 1. Possess at least 10% ownership in the entity at the time of adjudication and grant of parole, and 2. Have a central and active role in the operations such that his or her knowledge, skills, and experience would assist the entity to grow in the U.S.
How will the entrepreneur show the potential for rapid growth in the U.S.?
This can be accomplished in a number of ways. First, significant investment of capital of $250,000 from qualified U.S. investors with established track records. This would normally mean that the investors are venture capital funds, angel investors, or startup accelerators. This could also be accomplished if the investor has a proven track record of investing in companies that did well. You should note that this could not be satisfied if the entrepreneur invested their own money only. Second, government grants of $100,000 or more. They must be U.S. federal, state, or local government entities with expertise in economic development, research and development, or job creation. Ideally, it would be better if one could meet one of those two requirements. If not, an alternative criteria is submitting additional, reliable, and compelling evidence that the entrepreneur would provide significant public benefit to the U.S. and would create jobs. Evidence that may work include the following: a business plan, contracts, letters of intent, expert letters, or evidence of jobs already created. Here's a quick recap slide. You can pause at any moment.
How long can the International Entrepreneur Parole status be granted for?
The initial grant is 30 months. If certain criteria are met, this can be extended for another 30 months.
How many people can receive the parole status for one startup?
3 entrepreneurs from the same startup can receive the parole status. You should keep in mind that some of the evidence will not change from investor to investor. For example, if one business has an investment of $250,000 from qualified investors, all 3 entrepreneurs would meet that particular part of the rule.
Can I travel using the International Entrepreneur Rule?
The approval allows you to enter the U.S. once in parole status. Once in the U.S., you can apply for something called advance parole. Once this is granted, usually within 5 to 7 months, you can travel using this advance parole card.
How are family members treated on the International Entrepreneur Rule?
A spouse and children under 21 can join the primary applicant in the U.S. Both spouse and children can go to school, and the spouse can work if he or she submits a petition for work authorization.
Does the entrepreneur have to personally invest?
No. The entrepreneur does not have to invest their own money.
Can I apply for the International Entrepreneur Program with an existing business?
To apply for this program, the business must have been recently formed. This is defined as formed within the last 5 years.
Can the entity be formed outside of the U.S.?
No. The entity must be a U.S. entity.
Does the entity have to be a particular type of entity?
No. The entity can be an LLC, corporation, partnership, or other entity as long as it is legally formed in the U.S.
What is needed for the renewal after the first 30 months?
To renew the parole status for an additional 30 months, the entrepreneur must meet the following conditions. 1. The business is still a startup entity and was created within the last 5 years. 2. The applicant is still well positioned to advance the business, continues to own at least 5% of the business, and continues to have an active role. 3. The entity still has potential for rapid growth and job creation. There are several ways to satisfy this, including additional investment or grants of $500,000 during the initial parole period, revenue generation of at least $500,000, with average annualized revenue growth of at least 20% during the initial parole period, and job creation by creating 5 full-time jobs during the initial parole period.
Does the International Entrepreneur Rule lead to a green card?
No. This program permits for temporary status in the U.S., up to a maximum of 5 years. To stay longer in the U.S., you would have to find an alternate visa status.
What visa options are available to someone after the parole period ends?
The following visas could be considered if the applicant meets the criteria: E2 Investor Visa, O1 Visa, EB2 National Interest Waiver, EB1A, L1A or L1B.
Can I adjust or change status in the U.S.? For example, if I am eligible for a national interest waiver, could I adjust status in the U.S.?
No. Because parole is not considered an admission to the U.S., parolees cannot adjust or change their status in the U.S. If the applicant was available for another immigration benefit, such as the national interest waiver, they would have to obtain this at a consulate. To learn more about the International Entrepreneur Rule, take a look at the resources in the description below. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule a consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.